Its mission is access to the courts, access to justice, equal justice, justice for all. Its mission is to see to it that the courthouse doors are just as open for the poor as for the rich.
For 150 years, America's inbred sense of justice and fairness has supported some form of civil legal assistance for those in poverty. It began in 1865 in D.C. and across the South as part of the Freedmen's Bureau efforts to assist recently released slaves. In 1876, a legal aid office was set up to help German immigrants in New York City. Voluntary legal aid societies then began to appear in many cities, with dozens in place by the early 1900s. By 1960, the yearning for equal justice melded with the fervor for civil rights across the nation, and by mid-decade helped make civil legal aid a central part in Lyndon Johnson's new Office of Economic Opportunity.
There was a time in the 60s when there was a great deal of concern about poverty. There was a great deal of concern about civil rights. Both Robert Kennedy and, surprisingly, Lyndon Johnson were extremely interested in trying to lift the poor out of poverty. And I think a piece of that was legal services.
With support from Johnson's Office of Economic Opportunity, legal services had opened in 12 New Jersey counties by 1967.
Newark Legal Services was one of the first programs formed in late 1966. The very next summer, the Newark civil uprisings convulsed the city, and the young program faced major challenges.
Back then, everybody was young. The staffing of the legal services program when I joined them as a student was 2 directors and me. That was it.
It was not liked by the local bar association because it was a new thing. And we had a fight on our hands even getting started. We also had to establish credibility with the poverty community, who thought of us as white lawyers from the big city who probably aren't going to take a risk for us.
We did entitlements, we did matrimonial, we did consumer, and we did the whole gamut of landlord-tenant and the like. But those programs were very new. So the court system was not used to seeing people without money coming into a courtroom and starting to assert defenses or even to file cases on their own.
When I started in New Jersey at Camden Regional, most of the work we did was related to the habitability of the dwellings. That is, people were living in apartments, the conditions were worsening, and we fought to get the rents reduced or get the conditions remedied.
And here was this poor tenant with 1 toilet in a small apartment that had stopped working. Tenant had called upon the landlord repeatedly, come and fix it. Landlord refused to do that. And so the bright guys that were working with me came up with the idea of an implied covenant, which would entitle us, after notice, to deduct from the rent the amount needed to do the repairs to the toilet and remit the difference. Well, that's what we did. And the landlord said, I'm not going to accept the difference. I want the full amount of rent. So the eviction proceeded, and the case went up, and the Supreme Court decided it.
Marini overturned tenancy law, moving away from property law to contract principles and finding an implied covenant of habitability that became a national model.
Other landlord-tenant cases, such as Union County's Burzito versus Gambino, and housing cases such as South Jersey's series of Mount Laurel challenges, broke new ground in protecting and expanding safe and affordable housing. Legal services made strides in other areas of law as well. In State versus Shack, legal services lawyers who sought access to farms employing migrant workers were charged with but eventually cleared of trespassing. And Chris versus Division of Youth and Families recognized for the first time the right of parents to have legal counsel in proceedings to terminate parental rights.
Chris was our client. We went up to the appellate division, seems kind of incredible that the state could come in and take someone's child without their having legal representation, but that's the way it was. So we challenged that.
With success came political backlash, threatening New Jersey when Vice President Agnew intervened to try to stop Camden Regional Legal Services from suing the city of Camden to block it from displacing low-income communities for a new highway. In 1974, however, as his last bill signing in office, President Nixon authorized the creation of a new federal public corporation, the Legal Services Corporation, in the hope that the LSC would be free from political interference. By 1980, as a result of quadrupled federal funding for the LSC, there was at least nominal legal services coverage in every state, county, and parish in the United States. With this coverage came a nationwide infrastructure, national and state support centers, national, regional, and state training, and national delivery and performance standards for grantee programs. The tide quickly turned, however. Threatened extinction and then severe budget cuts and further restrictions in 1981 under the new Reagan administration crippled legal services nationally and in New Jersey. Legal services programs had to rethink how to help clients in the face of such cuts.
We went on there to identify that one of the things that we should do was legal writing for the community, not only a monthly newsletter for the community on legal topics, but also a series of legal handbooks. We were slated for zero funding, so it added a greater urgency in doing these handbooks.
After Congress refused to terminate the LSC in 1981, the new Reagan board appointees and staff set about trying to dismantle legal services from the inside. Despite sustained and often odd LSC episodes such as midnight raids on their own regional offices and targeted monitoring of grantee programs to try to find a reason to eliminate them, these dismantling efforts also failed, and a more moderate tone emerged nationally toward the end of the decade under the George H.W. Bush administration.
In New Jersey, the legal services system had earned great respect and strong bipartisan support at the state level, and increases in state appropriations during the 1980s helped legal services survive and expand its ability to represent more people. By the end of the decade, New Jersey became one of the last states to garner funds from a new funding source called Interest on Lawyers' Trust Accounts, or IOLTA. By 1991, the 25th anniversary of Legal Services of New Jersey, the national pendulum was about to swing yet again. In 1992, the Clinton administration supported LSC funding and more supportive LSC leadership, including New Jersey's Douglas Eakley as LSC board chair. Unfortunately, in 1995, the tide suddenly reversed once more. Leaders of the new 104th Congress again proposed the elimination of the LSC. Fortunately, there was enough political support to preserve the program, but at the cost of another round of severe funding cuts and still more restrictions on legal services work.
In New Jersey, fortunately, 1996 legislation dedicating $8 million in court filing fees to legal services, spearheaded by L&J Board Chair Michael Cole, shielded New Jersey from these new federal cuts. IOLTA and state funding allowed New Jersey legal services to meet more of the critical need for legal representation. Starting in 2007, however, the onset of the Great Recession caused legal services IOLTA funding to drop precipitously, from $40 million to less than $6 million. Combined with the reduction from $30 to $15 million in state legal services funding during the early years of the Christie administration, from 2008 to 2012, these cuts caused New Jersey legal services staff to decline from 720 to just over 300, and annual new cases to drop from 70,000 to just over 40,000.
Legal services pendulum swings will continue, seemingly ever faster, but inexorably they do bend toward greater justice. New legislation at the state level in 2014 authorized dedication of $10 million in filing fees as increased revenue to legal services in New Jersey, partly making up for prior cuts. While this still left legal services more than $20 million behind where they were as a funding level in 2008, important rebuilding of staff numbers and caseload followed. Nationally, However, and more recently, the new Trump administration has once again proposed zero funding for the LSC. While this new elimination effort will fail, more federal funding cuts are definitely a possibility in the near future.
Legal Services has, with the support of a great many, survived all these challenges and now looks to the future with renewed determination and capability. Buoyed by the energy and skill of new generations of staff, those of us who will carry the torch of justice into the future are confident that we will extend and expand Legal Services' wonderful record of service and impact, making full use of the power of technology and innovations in the provision of essential legal assistance to those who cannot afford it.
Summing up for Legal Services in its first 50 years, over 2.4 million cases handled on behalf of nearly 8 million individual clients. A catalyst for major positive change in every area of law that affects low-income people, including some 800 reported judicial cases. Through our websites, publications, and outreach, we help another at least 1 million people every year, providing some legal assistance and information. Looking forward, America's better self, its yearning for fairness, will persist as long as there are courts and lawyers and laws. Legal Services is a key instrument for safeguarding rights, but even more importantly, for protecting the lives and well-being of the most vulnerable people among us. To liberally paraphrase former Senator Edward Kennedy, the need is great, the cause is powerful, Legal Services will endure, and the quest for justice will never die.